I'm attorney Justin Ziegler of JZ Helps, a Florida injury law firm. Today I'm going to talk about what it means when an insurance company admits liability in your personal injury case. Stay tuned for the entire video because I'm going to talk about the effect of the insurance company admitting liability in your case, when they're likely to admit liability and when they are not. JZ Helps, a Florida injury law firm. Admitting liability is also known as clear liability. When an insurance company admits liability, it does not automatically mean you have a great case. There's a chance the insurance company could admit liability and you still could have a very difficult time proving that your injuries were caused by the accident. Admitting liability generally means that there will be bodily injury insurance coverage in your accident. However, that's not always the case. I'm going to give you an example of when admitting liability does not mean you have a good case. Let's assume you're rear-ended by someone insured by Geico Insurance Company. However, you wait 30 days after the accident to see a doctor. Now, because you're rear-ended, Geico says that they're accepting liability for your accident, which is very good. You're in a good mood, you're excited. Just because Geico says that they're accepting liability, they are still going to discount the value of your case in most cases for the fact that you waited 30 days to see a doctor. They're going to argue, most likely, that your injuries were not caused by the crash. Whereas if you would have treated the day of the accident or the following day, they may fight you on this issue a lot less. If an insurance company admits liability in your case, there's generally speaking a lot less likelihood that you're going to need to sue them, which is very good. It saves you time, stress, and money. When you sue someone who has insurance, even if the insurance adjuster believes that their insured is at fault, they generally deny liability, at least in the beginning of the lawsuit. And as things progress, they may admit liability. The effect on this is, if they wait a certain amount of time to admit liability, your attorney can generally charge 40% of the total gross recovery. The most common situations where you're going to hear that the insurance adjuster admits liability is if you are rear-ended, if you're hit by a drunk driver, if the driver that caused your accident was cited for reckless driving, not careless driving. There is a difference. Reckless driving implies that the careless driver was driving recklessly and it was intentional. He knew what he was doing. An example of a case I sued where the defendant ultimately admitted liability was where my client was injured on a Carnival cruise ship. He was getting off the ship and onto a tender which transports the passengers to shore. The rope snapped and struck his elbow. Now, at first, Carnival denied liability, then they ultimately admitted liability, but they still fought us on causation and damages, essentially arguing that my client's alleged shoulder impingement was not related to the accident. We said that his shoulder impingement, the pain in his shoulder, was caused or aggravated by the rope snapping, and Carnival disputed that. So it's just an example of how even if the defendant admits liability, you still can have an uphill battle. Carnival ultimately settled the case and paid us $22,000. Even if the insurance company admits liability, you should always expect that the settlement release that you are going to be required to sign at the end of the case will say that liability is denied. There's not a big issue with that at all. I hope you got a lot out of this video. Please subscribe. Please comment. I'm attorney Justin Ziegler. My office is in Miami, and I serve the entire state of Florida. Have a great day.